question be now put.
Chris Hipkins.
Mr. Chairman. Mr. Chairman, I want to say at the very beginning of this contribution that I was absolutely shocked and absolutely appalled to hear the Minister of Police, the Minister of Corrections, in fact, rise in this House and suggest that the only violent criminals were in South Auckland, and that somebody who lived in central Wellington or in Christchurch or somewhere else...
Point of order, the Honourable Judith Collins.
If the member's going to make silly statements like that, at least quote me correctly.
No.
I live in South Auckland, Mr. Hipkins.
Sit down. Look, these are debating points. Sit down. These are debating points, and it's a robust debate, but I'll ask you to continue, and the Minister, I'll ask you just to refrain from those comments. These are debating points. It's not a point of order. Chris Hipkins.
Chairman, I'm not surprised the Minister's embarrassed by the comments that she made before. It's a comment that Melissa Lee would have been proud of about South Auckland. Perhaps they should just build another motorway so that all the criminals can drive past South Auckland. It was an absolutely disgraceful indictment on the government. It was a further disgraceful indictment on this government for the fact that Judith Collins, the Minister of Police, in fact, said that anybody that opposes this bill is condoning the actions of violent criminals. I was offended by that. I am opposed to this bill, but I think the actions of violent criminals are abhorrent. And I actually want to say thank you to David Garrett for at least having the decency to acknowledge that people who oppose the bill aren't condoning the actions of violent criminals, do actually take the considerations for victims into consideration. I find it offensive that the Minister would not do the same. David Garrett had the good decency to at least acknowledge that much, even though we may not agree on this particular bill. Ms Collins' own police association, the people who she works with, in fact, have argued against the removal of parole. In their submission on this bill, they argued against it, and they talked about judicial discretion providing a safety valve for the myriad of possible circumstances surrounding any given case, and argued that it is preferable to mandatory sentencing. That was the New Zealand Police Association, who argued there is a very real cost to removing all hope of early release, and such that inmates often become very difficult to manage in the police system and the prison system. And I want to say, I just think it would be appalling for the Minister of Police or the Minister of Corrections, whichever government they come from, to have to come into this House, as the Minister did this afternoon, very tragically to offer the condolences to a family of a prison officer or a police person who's been killed because of this bill, because evidence that was presented from overseas suggests that that is more likely under this bill. And for the Minister to say that by putting up these arguments, by opposing this bill, that somehow we condone the actions of violent criminals and violent offenders is simply offensive. It's appalling. Mr. Chairman, I want to talk about some of the other concerns that were raised by the very valid submissions put forward during the Select Committee process. I have had the opportunity, I did not have the opportunity to sit on the Select Committee. I have had the opportunity to read through some of those submissions. The Dunedin Community Law Centre pointed out very well, I think, that the Parole Board now declines 72% of parole applications, and that's actually a significant increase from 52%, which was the rate before the last legislation came into effect. And I think it's really important that we consider the 2004 legislation, because things have changed. So when David Garrett talks about, what's happened in the last 20 years, well, there has been a significant change in the last 5 years, in fact, that we wouldn't have seen the full effect of. So I think we need to consider the changes made in 2004, the impact that that's having on the parole that is granted, the impact that's having on the sentences that are imposed in the first place, including the amount of mandatory non-parole that is imposed. The average non-parole period imposed for life sentences increased by more than 25% between 1997 and 2006. Now, I think that's really important. That was a point raised by the Dunedin Community Law Centre. They also argued that women would be less likely to report violent crime, in particular violent crime involving their partner, if they knew that their partner or former partner or father of their children or other relatives could be locked up for life. So we have to consider the implication this law would have on the reporting of crime in the first place, the willingness of victims to come forward, the willingness of victims to actually make statements, to provide evidence that can be used in and prosecutions. A retired judge of the District Court, William John Mitchell, argued that ruling out parole, even after genuine efforts towards reform, reduces the incentive to make such efforts. Surely we should be looking at how we create more incentives for prisoners to actually genuinely reform themselves. And we have evidence here presented by a judge that this bill won't do that.
Move that the question be now put.
The question is that the question be now put. Those of that opinion will say aye. Contrary will say no. The ayes have it. Party vote. I'll ask the clerk to conduct a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
43 votes opposed.
Green Party.
9 votes opposed.
Act New Zealand.
5 votes in favour.
Maori Party.
Eri mga pōti kore pakai.
Progressive.
1 vote opposed.
United Future.
1 vote in favour.
Members, the ayes are 64, the noes are 58. The motion is agreed to. The question now is at part 2, stand part, but before we do, we have the Minister's Amendment. The question is that the Minister's Amendment set out in SOP 123 be agreed to. Those of that opinion will say aye. Contrary will say no. The ayes have it. Party vote. I'll ask the clerk to conduct a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
43 votes opposed.
Green Party.
9 votes opposed.
Act New Zealand.
5 votes in favour.
Maori Party.
Eri mga pōti kore pakai.
Progressive.
1 vote opposed.
United Future.
1 vote opposed.
Members, the ayes are 63, the noes are 59. The motion is agreed to. The question now is that part 2 is amended, stand part. Those of that opinion will say aye. Contrary will say no. The ayes have it. Ayes have it. Party vote. I'll ask the clerk to conduct a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
43 votes opposed.
Green Party.
9 votes opposed.
Act New Zealand.
5 votes in favour.
Maori Party.
Eri mga pōti kore pakai.
Progressive.
1 vote opposed.
United Future.
1 vote opposed.
Members, the ayes are 63, the noes are 59. Part 2 will stand part. The question is that schedule stand part. Those of that opinion will say aye. Contrary will say no. The ayes have it. Party vote. I'll ask the clerk for a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
43 votes opposed.
Green Party.
9 votes opposed.
Act New Zealand.
5 votes in favour.
Maori Party.
Eri mga pōti kore pakai.
Progressive.
1 vote opposed.
United Future.
1 vote opposed.
Members, the ayes are 63, the noes are 59. The schedule will stand part. Members, we now come to clauses 1 and 2. The question is that clause 1 and clause 2 stand part. The Honourable Leanne Dalzell.
Mr Chairman, this Act is apparently called the Sentencing